So Chille gets the last word. You file your appeal, your opening brief. The people respond to it, and then you file what's called a reply brief, the last word. This is the reply brief, the last word, plus the appellate court asks for supplemental briefing. And I think that it doesn't do the job. So let's take a look. I've entered the twilight zone, so now I'm in black and white. Here is the reply brief. And once again, it's not too impressive. You don't have to simply say you're replying to the respondent's answer to the appellant's opening brief. You just simply say appellant's reply. We continue with the ransom note style of formatting with capital words in the middle of sentences. Comes now, like I said, I'm glad that they learned how to spell that correctly because they have a tendency to create typos within their documents, which never impresses anyone. Jose DeCastro by and through his attorney of record. Who else? You don't need to say that. Hereby submits. Well, you're just submitting. You don't have to hereby anything. And then this would be in quotations, respondent's answer. And it's not respondent's answer to appellant's opening brief. You're replying to the respondent's answer. I think they would get that. This brief, capital B, doesn't need to be that way, is made and based. How about is based upon? You don't say made and. Already on file herein, the points and authorities, which sounds like a motion. Attached here too. Well, attached, what do you mean attached? You gotta look for it. And any oral arguments, wrong. That's plural, adduced at the time of hearing, and then they left the word on out this matter, and they can delete that and on and just put a period there. Which needs a comma there. Anyway, arguments, First Amendment protections, whatever. In this case, you'll see the constant mistake of a quotation mark period, and the word clearly, I told you to avoid that. They also use a lot of sentence, I call them interrupters. In this case, we'll see a lot of that. Began filming a police interaction from 10 feet or more. The police interaction, see police interaction. Comply with officer's demands to back up. Wrong, he didn't. He actually said no. Provocative, challenging speech throughout this brief. He doesn't exactly describe what that provocative and challenging speech is if he's seeking First Amendment protection for it. That's a mistake. I started rewriting everything here. The state never disputed Mr. Castro's constitutional right to film the police. That's another thing through this brief. They keep talking about the right to film. No one's contesting that. Why are you arguing it? Why are you wasting time? And then with my edits, you just eliminate the rest of this. What agreement are we talking about here? Mr. Castro somehow obstructed the officer. Really? What are you talking about? The state contends, not repeatedly, get rid of that Mr. DeCastro refused to back up as proof he obstructed the officer. See how I got rid of all that extra unnecessary words, including this. At trial, well, where else would it be? Officer Bork, you'd say Bork, testified that he did not back up. Hilarious, because the way they've written this, he then refers to Bork. Now Bork was supposed to back up to his own commands. They make a colossal mistake in taking a pronoun and misapplying it and putting it in the wrong section. This is supposed to be outside the period quotations with the citation to the authority, spoke generically about a 21-foot rule. Remember, that's subway, Jared. 21 subways is a 21-foot rule, comma. Get rid of all of this, and that DeCastro violated this. No, there really isn't an issue with this 21-foot rule. And then because Bork didn't back up, on appeal, here is the typical, like belie, they used that before, it was a bad word, notably on appeal, on appeal, on appeal. At trial, once again, they use the same thing in this case, in glick, they'll use in many, many times here, typo, all conclusory. A reviewing court can simply review. You can get rid of the word simply. And this, Castro complies, that's the wrong tense, ought to be complied. And it's irrelevant anyway. These rhetorical questions, which just waste and chew up time. Even firmly established Supreme Court case law is not the truth of statement. That's just argumentative. It doesn't prove anything. On appeal, notably, they always like to use that one, notably. Well, if it's in the brief, it's supposed to be notable because the idea is that these are mistakes. In the Glick case, in Glick, activity, we don't care about filming the cops. This is all conclusory. Conclusory means it doesn't prove anything. Don't explain why or how. Uncontradicted federal law, good luck with that, because anyone who studies case law will notice that there's always contradictions. If there wasn't contradictions in case law, distinctions, whatnot, we wouldn't need appellate courts, now would we? This is land of the inn. in their appellate brief, in a footnote, actually in fields, in ironic, or whatever, in fields again, in essence. It's just ridiculous. All of this is irrelevant. Rodney King, why waste your time talking about it? In a footnote, the state appears to take offense to DeCastro's reliance on the George Floyd. I don't know that you would take offense to any of that. Appears to argue, well, you really want to say what they are stating as opposed to arguing. Ironically, the Fields Court utilized the same exact reasoning as Mr. DeCastro. What does that mean? That's just more fluff. This sentence is so long, I had to take a breath. What I first did is I just started lining out stuff. So many words here that it just gets in the way of itself. It goes to Rodney King, the Floyd killing, which has nothing to do with him. Scoured. What do you mean scoured? Why would you even say that? More interrupters next, moreover, ultimately, finally, just ridiculous. These are awkward transitions. Nothing in these cases supports the state's position. That's just conclusory. Instead, they further bolster that's just conclusory. There's no actual analysis. The state's reliance on the numerous cases cited in their brief either significantly assist. That's just conclusory. Adds nothing. Comically bad to write an appellate brief. However, in reality, another rhetorical question. Notably, once again, we saw that a few pages back. This is a mistake. Times, places, and manners. Remember, it's time, place, and manner. So they've got it plural when it's supposed to be singular. This was already repeated in the prior brief. This is the time to not keep repeating things. You want to keep bringing up new arguments. Rodney King again, provocative, challenging language. You're claiming First Amendment protection, but you're not stating what the language is so that the appellate court even knows what you're talking about. It's not the appellate court's duty to figure out what your arguments are and make them for you. He then grabs Mr. DeCastro in an aggressive manner. Most people, when you grab him, it will be aggressive. Ultimately, again, problematic for the officer in federal court. How's that? I looked at the federal court case against the cops. The federal judge said there was probable cause to arrest, and it's now hanging by a thread, subject to a motion for summary judgment. So I don't think that this has been too problematic. Another interrupter, unfortunately, provocative, no explanation what that is, must be overturned. Now we get to the 4th and 14th Amendment. First time I heard that one. Counts 1 and 2, if you ask me, there should be, it's plural. Must be dismissed, very aggressive language, telling the judge how to think. Additionally, another interrupter did not resist arrest, conclusory, as he was unlawfully arrested, conclusory. At trial, where else would this be that the cop was unable to articulate his behavior? Officer simply testified, the word simply again. There would be, you would rephrase this with a capital A in brackets. And then all I saw him in recording, which again, I had no issue with. Well, why would you put that in there? Now you're showing that filming is not the issue. You just prove that through his testimony and through citation in the record. Convicted of attempting to obstruct. Well, there are attempt crimes. It's not an attempt crime. This is an actual conviction, so that's wrong. Again, another interrupter, unpublished authority for stubs. I know here in California you don't do that. There's very limited reasons for it. The Nevada Court of Appeals carefully examined. Why wouldn't they carefully examine? Why would you even say that? Are you saying that in other instances they don't? The court determined that specific intent is a requirement of the statute. Yeah, that's true, but then there are exceptions. The court further held, how about the court held that, therefore we interpret, you say the court held that, quote, NRS applies, put a bracket here to change the actual word here, so you know you're changing from applying to applies only to physical conduct and fighting words, but there's the exception, blocking the path may amount to obstruction, true. So now you put in the exception that can get you in trouble. In other words, passive aggressive actions can still be considered physical conduct because like the Wilson court said, we cannot write a law that addresses everything. That's true. Another in beginning this one, and he agrees that fleeing would be hindering obstruction. Why would you put that in there? It has no relevance. The Wilson court determined that NRS prohibits only physical, but this is just restating what you just said. And so it doesn't help you. I'm looking for analysis. In Wilson, another starts with preposition in. The real issue, oh, wow, I'm glad you found that for me, what the real issue is. The court explained, the court remanded, enunciated. You don't need to do that. You just need to say things in simple terms. Mr. DeCastro was never seen physically attempting to obstruct the officer. What does that even mean? This is all speech area. This is all irrelevant, all conclusory. Never willfully resisted the police is all conclusory. Now they're unconstitutional. Another one starting with in. Denied state and federal constitutional rights. Still on this stuff. I just started rewriting this just to start cutting down the language. during the trial proceedings. You don't need to say that. Just wasted words. How about just saying the judge was biased against DeCastro? Very good opening sentence. It sets the tone. Now you got to explain why. But now they're saying it's because he was forced to empty his pockets and because she said she didn't want to be on a YouTube video. That was a rule that she enforced against everyone. And he gets it wrong here. He says defense counsel is also ordered to turn off his phone. Okay, fine. The judge could do that, but the judge said he was a court officer. Failure to demand that the prosecutor turn off her phone or surrender her cell phone to the marshal. I think that's capital M. Well, me did not give up his phone. The judge said specifically that he didn't have to, and she wasn't going to insist it because he's a court officer. So this is contradictory. You're saying that the judge applied the law in an unconstitutional fashion when she made everyone in the courtroom, other than court officers, hand their phones over to the marshal because you have been known for filming things. And she is adhering to a rule that the only ones who can film are those who submit a request, like our Nevada judges. That doesn't make her biased. Now, if you're arguing she was biased against him because she gave him extra time because of how he acted at the end, the trial was already over. And she has the discretion to do this. Remember, she gave mid-range sentences. So that won't show an abuse of discretion. Would it show bias? Well, they did bring up a good point on Chille's side. If they've looked at 200 cases and they found that in every time that she's convicted somebody, she's never sentenced them to jail, that would definitely raise questions. Is that in this brief? I don't see it. The court did not enforce a universal prohibition on recording. Actually, it kind of did, except for those who comply with the rules. And now this is supposed to be violating the equal protection clause. Listen, you go into a courthouse, you surrender your rights right away. It's on the doors. Hey, you can be subject to arrest. You can be subject to search. You got to consent to go through the scanners. And if you walk into a judge's courtroom, she has the right to enforce security. In her mind, this was a security issue. She didn't want it done. He will rely upon the case law cited in his opening brief regarding the implied will rely, more interrupters. If you're going to say first, then say second and third. Don't say first and then switch to however. They go into a little bit of analysis here. I looked at the Echeverria case, and the idea is that you don't have to prove actual bias. A reasonable person looking at the things holistically could say that even if the judge isn't trying to be biased, there's a tendency to think that he or she could be based on whatever. Well, if you're saying it's because of the phone thing, you're not going to win on that. It was all cited wrong. This is actually page 1130. You would revise these sentences. The clearly word, ineffective assistance account. This is all word salad. I started knocking things out. Would rely upon. Why do you even use it? It's just asserts, use active voice, use different form of verb tenses. In this case, more ends. This is all a sideshow here. The convictions were based on conduct. If this was the First Amendment issues, once again, they were not even described in this brief with any kind of clarity. So they're saying that me didn't describe them or brief them or use them to wipe out the charges, but I don't see them doing that here either. Kind of funny, right? Also, by claiming that she's biased, she also granted you trial continuances when you wanted them. And so, I don't really see anything better here. This is something that happens during trial. You don't get a perfect trial. You're supposed to get a fair trial. All conclusory. They finally bring up Wilson, but they don't really do much to discuss it. And then wherefore, you don't really need to say that. He respectfully, as opposed to disrespectfully, requests it. All right, so I'm back out of the land of Oz. There's nothing here that I see that's going to change anything. This was just a bunch of words all thrown on paper. It doesn't really do anything for me. It doesn't help move the needle. It's basically referencing the Floyd case, the Rodney King case. It's like grandstanding, like he's the grand victim here. I see the convictions not being changed. There's real no in-depth analysis. It was all superficial.